Welcome back to Eyewitness News this morning. We're joined by Charley O'Hara here to answer your legal questions. And we do have a caller on the line with a question right now. So, hey, caller, if you're there, you can ask your question to Charley.
Yeah, my question is if you have a nonviolent felony and it's expunged, can you own a firearm?
Well, expunging it, I don't think actually gets you out of the problem with it. It's a conviction, and if you have a felony conviction, any felony conviction, you can't have a firearm for so many years. Now, the problem with all that is they tend to change the length of the time you can't have a firearm, kind of depending on the politics of everything. And then also the state, the federal, that's state law. Federal law says once you have a felony, you can never have a firearm. However, that's been interpreted to go to state court. So I think anytime you're looking at getting a firearm after you've been convicted of a felony, you've really got to check with the Attorney General and everybody and make sure that you're okay before you do that. I'm always very reluctant to give people advice in that area.
Are there any other restrictions about background checks on guns too? If you're going to purchase a gun, does domestic violence play a role in any of those background checks?
It does, and so you've really got to check and make sure that you can have that firearm. Don't be assuming because you read it on the internet or people tell you that. It's a very unclear part of the law, and you really need to check and be clear before you go do something like that. Because you get in trouble if you buy that gun and you're not supposed to.
Absolutely, and as would the person who sold you that gun.
That's correct.
If you don't go to a gun store, if you buy it from a friend, so aiding somebody, and we're talking about that specifically, aiding the commission of an act like that, a felony, anything like that. Talking about Orlando right now, people saying the shooter, Omar Mateen's wife, could face charges for not warning police about what she possibly knew of the attack. What's the situation there, Charley?
Well, if she helped him do anything, if she, the classic law school story is you drive somebody to a bank, they get out, you know they're going to go rob it, they go in and rob it, you never go in, you're guilty of bank robbery. You drive them to the bank, they jump out of the car, they go in the bank robbery and shoot somebody, you're guilty of murder. You never had a gun, you never went in there. However, if she helped him plan that stuff, she's in trouble. But if she may have helped him plan it and then decided, no, I'm not going to do it, and tried to stop him, well, then that becomes somewhat of a defense. So I think it's being investigated right now to determine exactly what she did. If she really tried to stop him or wasn't involved in it, I don't know what her real duty is to turn him in. It gets into a real kind of a gray area again because she's married to the person. Some of those things are marital statements. And what she has to tell the government, what she doesn't have to, is another gray area. But if she actively helped him and didn't try to stop him, then she's got real problems.
Seems like this is going to be kind of a hairy situation to figure out on that side.
It will be.
All right.
Be very interesting.
And see if there's any coercion, too, on his part. So definitely something we'll follow for you and give you the latest updates on that. Thanks so much, Charley, for being here, clearing that up a little bit. We'll see you guys back here right after this.